Now, we take that conversation on jurisdiction a little bit further and the contradictions that are coming out of there with the University of Pretoria legal expert, Dr. Llewelyn Curlewis. Dr. Llewelyn, good evening, and thank you very much for your time and for joining us tonight up here on In Focus. Now, the court in which the cause of action of a matter arose in any other court which has the geographical jurisdiction over an area, it's said to be the court that is meant to hear this matter. So what happens if a court without jurisdiction hears a case?
Okay, before I answer that question, I must make two remarks from what you have mentioned earlier on. The first is that Advocate Tefo made numerous unsubstantiated allegations in court today, one of which is that the DPP's office was corrupt allegedly, and then at some stage he was even reprimanded by the judge for leading evidence from the bar himself. And then for some reason seemingly also interchanging between being defense counsel on the one hand and subsequently also having a hat on as a so-called watching brief on behalf of the brother of Senzo Mahiwa. That is really mind-boggling. But be that as it may, getting to your question on jurisdiction, with all due respect, once again, and I'm trying to be as subtle and respectful as possible, basic principles of law is entertained in this matter, which, as far as I'm concerned, my first-year student, undergraduate students are supposed to know the answer to. If we talk about jurisdiction specifically, then we are saying jurisdiction generally referred to the authority of a court, obviously, to hear and decide an issue on a specific matter, whether it's a trial, an appeal, or in a review. So in other words, if jurisdiction is raised and successfully raised, then that court can not attend to the matter, as simple as it gets. But in this specific instance, the Superior Courts Act, specifically Act 10 of 2013, is strike law on this. Namely, to be specific, it distinguishes between the composition of, or the constitution of a high court, so-called main or permanent seats, and so-called local seats. The first mention, we have 9 divisions in this country. And then on the local side, the local seats, currently there are 7, and it might be increased in the future. But in this specific instance, we used to refer to the Pretoria division, in other words, the Gauteng North division, as the so-called provincial division. In terms of the Superior Courts Act, we are currently referring to it as the so-called main seat or permanent seat. And the Johannesburg Gauteng division is the so-called local division or local seat. Now, the main seat has so-called concurrent jurisdiction over the areas of jurisdiction of a local seat. In other words, in plain simple English, parallel jurisdiction. In other words, the matter can be attended to either in Joburg or in Pretoria without any problem whatsoever. There's no need for argument or heads of argument or papers to be served on one another to have this issue deliberated and debated.
So Carlos, I don't know if it's the same terminology. Maybe in South Africa we use a different terminology, which you've just mentioned now. But there are some courts that speak of a court of general jurisdiction. Is that what you would call the High Court?
That will typically be your High Courts automatically have so-called automatic jurisdictions. They can attend to any offence whatsoever. But the main argument in this matter of Senzo turns on the question whether the matter should have been attended to in the Johannesburg High Court or whether in the Pretoria High Court. And that is exactly where everybody has a draft. Because there's absolutely no problem with the court as such. Either court can attend to the matter. And just to make it more specific, in this very instance, Advocate Tefo and all the other stakeholders, defense lawyers, they participated in ensuring that the matter continues after the plea was entered in court. So they had at least tacitly, in any event, consented to jurisdiction of the court. You cannot now,
can a defendant
during the course of this trial, go back and raise a matter that should have been attended to from the outset.
Can a defendant use the territorial jurisdiction argument as a defense in a case?
No, it's not a defense. It could be a special plea, but then it should have been raised from the outset before you pleaded not guilty and evidence was led in court. A typical example would have been what the defense lawyers did in President Jacob Zuma's case in Pietermaritzburg High Court. Even before evidence was led, they raised a special plea and said, listen, the prosecutor doesn't have authority to prosecute. So the court must first determine that issue before it can go to the main defense. And in this instance, Tefu and his colleagues allowed the matter to proceed, and now all of a sudden they want to go back to first base and ask the court whether the court has jurisdiction. They tacitly consented to it. But to make it even more specific, Section 111 of the Criminal Procedure Act, 51 of 1977, as well as Section 22 sub 3 of the National Prosecuting Act, 32 of 1998, specifically mention that the National Director of Public Prosecution has a discretion, the liberty to decide in which court the matter should be attended to. Okay. Whether the offense was originally to be investigated in one specific director's area or in another, it can be chopped and changed in accordance to the discretion of the NDPP. As simple as it gets. Yeah. There's no questions to answer here. There's nothing to debate on.
Now, who is responsible then for making sure that the cases are filed in a court of proper jurisdiction? Is it the judge's responsibility to determine this?
No. No, it's definitely that of the prosecuting authority, because they are what is termed as dominus litis. They are in charge of the proceedings because they bear the onus of proof. He who averts must prove, and therefore must see to it that you are in the correct forum. But I repeat, there's nothing wrong with the forum in this instance. We are in the correct court. No questions asked, as far as I'm concerned.
Yeah. Now, when we started, you raised issues of process, right? There are facts of the case in this particular matter, and then there's course of procedure. Is this going to have an impact on the outcomes of this case in how the course of procedure is being followed?
Look, at the end of the day, correctly remarked by the presiding judge, if any of the parties feels that there were certain irregularities, whether it's procedurally wise or even on the law as such, then they are at liberty, after the finalization of the matter before the court of first instance, in this instance the Pretoria High Court, they can then raise those issues simultaneously in one argument before a court of appeal, or preferably on review, because that is where a high court, a court of higher jurisdiction, will attend to the so-called irregularities that allegedly took place. So this is not the forum to debate these things, really. A court must merely see to it that the process is followed, finalized, and whoever is unsatisfied must then take the matter on further appeal based on those so-called irregularities that are identified. But, that being said, you must distinguish between the issue relating to the jurisdiction, which I'm sure there's no problem with, and any other possible procedural irregularities. Because a procedural irregularity, if correctly pointed out as such, that could be that the difference between a setting aside of a conviction, ultimately, or obviously the court of appeal or review saying the court of first instance was correct in all material aspects. Yeah. So that could be a determining factor. So correctly pointed out, Tabu.
Would a question of two regions of the NPA both investigating a matter and arising with two dockets be a procedural issue?
No, not really. That is internal preliminary aspects. Remember, in actual fact, only once the matter kicks off in court, by kick-off I mean when the process is starting with plea and the persons are arraigned before court, only then a prosecution starts off. What happened before is investigative issues. Yes, obviously the question would arise, but why two different conclusions? Is it because we're not sure about your own investigation? Because that is the best argument you can raise as far as that is concerned. But the prerogative always remains on the prosecuting authority. It is not a court of law that made a final decision on credibility or on guilty or not guilty of certain individuals. the prosecuting authority might finish this matter and say, for example, there was an acquittal on all 5 accused persons. And they can then further investigate the matter, and then in a year's time from now, they might just as well decide to charge Kelly Khumalo and prosecute her and see whether she's convicted. They are at liberty to charge any person, whoever they find could have been involved in the crime, randomly, as long as they are not acquitted and double jeopardy principles are not applicable. So this is probably not the end of the road.
Dr. Curlewis, appreciate your time. Thanks so much for coming on. Dr. Llewelyn Curlewis is a legal expert. He's with the University of Pretoria. Brings